Good afternoon, everyone, and welcome to the investiture of Professor Margareth Etienne as the Carl L. Vacketta Professor of Law. It is indeed wonderful to see so many friends, colleagues, and students here to celebrate this significant occasion. I want to make special mention of some special guests who are here to honor Margaret, including her two daughters, Madeline and Claire Keenan. Her sister, Anne-Marie Etienne Hester, who's here from Florida. And her brother, Junot Etienne, who's here from New York. Who I had the pleasure of having dinner with last night. So thank you all for being here. Investitures are a long-established tradition in academia to acknowledge and honor faculty who, over the course of their careers, have shown exemplary achievement in scholarship, teaching, and public engagement. And investiture as a named professor honors the very highest level of such academic accomplishment. In addition to celebrating our honorees and their families and friends, investitures provide an opportunity to honor donors whose vision and generosity make such events possible. The Carl L. Vacketta Professor of Law was established by a gift from Carl Vacketta, a distinguished 1965 alumnus of the University of Illinois College of Law, and a 1963 magna cum laude graduate of the University of Illinois College of Business. A retired partner at the law firm of DLA Piper, Carl is a loyal friend and donor and strong advocate for the college and for the university. The roots of his generosity and commitment to the university and college run deep. He is a member of the Dean's Advisory Board. He's a founding member of the John E. Cribbett Society. He partnered with the class of 1996 for the first class endowment gift. He established the Carl L. Vacketta Scholarship in Law for students and the Carl L. Vacketta Professorship of Law. And he was the co-chair of the college's $50 million successful Brilliant Futures capital campaign that ended in 2012. In addition, Carl serves on the board of directors of the University of Illinois Foundation. And in recognition of his support, Carl was the 2003 recipient of the university's prestigious William E. Winter Award for Outstanding Advocate Leadership. In 2013, he was inducted as an inaugural member of the University of Illinois ROTC Hall of Fame. And we are unfailingly grateful to Carl for his ongoing and extremely generous support of the College of Law. So thank you, Carl. Today we are joined by some distinguished leaders elsewhere on campus as well. We have with us the Dean of the College of Liberal Arts and Sciences, Investiture Patton, who I didn't know was coming until a few minutes ago, so I'm delighted to see you here, Investiture. Thank you for being here. And we have with us the Provost of the University, Andreas C. Cangelares, whose formal title is Vice Chancellor for Academic Affairs and Provost and M.E. Van Valkenburg Professor in Electrical and Computer Engineering. As the Chief Academic Officer, Dr. Cangelares oversees campus's academic programs, policies, and priorities, which are designed to ensure the quality of the educational experience for students and to sustain an environment that encourages and supports academic excellence through research, diversity, inclusion, and free inquiry, debate, and speech. In this role, he works closely with the Chancellor and other Vice Chancellors, the Deans of the academic colleges and other units, academic staff, the Senate of the Illinois campus, and various committees in setting overall academic priorities for UIUC. Prior to his service as provost, Andreas served as the Dean of the College of Engineering here, where in addition to his administrative service, he earned many international accolades for his own groundbreaking research. So Andreas has been intimately involved in maintaining and growing the excellence of this campus for many, many years and from many, many vantage points. Please join me in welcoming Andreas.
Thank you very much, Dean Amar, for this very kind introduction, and good afternoon to all of you. And congratulations to Professor Etienne for her special recognition today. I would like to make a few remarks, but if you would indulge me, I want to start with a brief reflection of who I am today, an academic, an engineer, but really what I wanted to be before I started high school was a criminal lawyer. And that is because on my father's side, his mother's brother, Nicholas Kritikos, was a very successful criminal lawyer in Greece, and he did have a good number of friends, but he had more enemies than friends. But I will tell you, the man was, for me, a young person, bigger than life. He would come to the island where I was born. Anytime he was getting ready for the big days, for his defense, and he would take me for a walk late at night, especially the winter days. You know, you could hear the wind and the sound of the waves, and the wind made it impossible for anyone to hear what they were saying, but not from my uncle Nicholas. And he will shout, and he will speak with so much passion and assertiveness. And I said, that's what I want to be when I grow up. And my father put an end to it. But I'm very proud to be here today to celebrate one of our distinguished colleagues and congratulate her for a career that speaks for itself. Being invested as a faculty chair at the University of Illinois by your colleagues is one of the most challenging and best proofs of how much you have accomplished as a scholar. But in particular, given the kinds of things that Professor Etienne is involved in her scholarly work and her teaching, those are such important elements in every democratic society. And for that, we are fortunate to have her as a member of our College of Law. I don't have to say much about the College of Law at the University of Illinois. We're very proud of our College of Law. We're very proud of its impact to the state of Illinois and the contributions it is making to thinking about the right, the just, and the way democratic nations need to go about their well-being. Professor Etienne is someone we're going to hear a lot about, but what I would like to spend also a few minutes to reflect upon on behalf of the Chancellor, myself, and of course, Tina Mar and the leadership of the university, is how these investitures bring together our community in unique ways. They bring together our scholars, they bring together their colleagues who evaluate and recognize the contributions of our scholars. They bring together our students who benefit from our scholars in two roles, both as students, but also as alumni, who celebrate the success that their experience here at the University of Illinois makes possible. So these are the kinds of events, these are the kinds of investitures that, as we reflect upon who we are as a university, as a public research university, reminds us of the fact that our community expands well beyond those who on a given day happen to be at the University of Illinois. Our alumni and those who are alumni serve in their various professional engagements or activities in their communities are a significant part of the impact, the size, the reach of our community. And as we reflect on Professor Etienne's accomplishments today, let us not forget that the impact Professor Etienne is having and continue to have throughout her career and beyond is not easy to measure. But we know and feel that is an impact that changes the world for the better. Professor Etienne, congratulations.
Thank you so much, Provost Cangelaris. Margaret Etienne joined the College of Law faculty in 2001, where she has ever since been an esteemed scholar and teacher in the areas of criminal law and procedure, sentencing, education, and children and the law. Her research focuses on decision-making, specifically how stakeholders in the criminal justice system operationalize laws and procedures on the ground, so to speak, and how their decisions in turn impact criminal law policy. She also writes, as I intimated a moment ago, in the area of children and the law, with a focus on educational policy and children's rights. Margareth has published in many of the nation's most prestigious journals, including the Stanford Law Review, the NYU Law Review, the California Law Review, the University of Chicago Law Forum, the Illinois Law Review, the Journal of Criminal Law and Criminology, the Texas Tech Law Review, the Connecticut Law Review, and many others. Indeed, just last night, I learned that she has a very interesting forthcoming piece in the Indiana Law Journal, which I look forward to reading very soon. She is also the co-author of the Illinois Judicial Bench Book on criminal law. Her work has been cited in numerous judicial opinions, and she has delivered more than 100 invited talks, lectures, and interviews about her research in the United States and abroad. She is a recipient of a Fulbright Scholar Grant. She's a fellow of the American Bar Foundation and is also a Public Voices Fellow. She was the inaugural Associate Dean for Graduate and International Programs, where she continues to oversee the College of Law's international endeavors, as well as the JSD, LLM, and MSL degree programs. She has served the campus and the college in numerous administrative positions as the Associate Dean for Academic Affairs, the Interim Department Head for the Department of African American Studies, and as a Provost Fellow for the University of Illinois more broadly. She has served on 2 Provost Search Committees, 2 Dean Search Committees, the Police Chief Search Committee, and several other appointments that have helped to shape the future of the university. She received her bachelor's degree in history from Yale University and her law degree from Yale Law School. After graduating from Yale, she clerked for Judge Diana Motz on the United States Court of Appeals for the Fourth Circuit. She later practiced criminal law as a federal public defender, where she argued cases in the Northern District of Georgia and before the 11th Circuit Court of Appeals. Her colleagues heap praise upon her scholarship, saying, quote, "Professor Etienne's contributions to the field have been sustained and substantial, earning recognition on a national level." And, quote, reading her work, you are constantly reminded that the law has real consequences for real people. One of her colleagues observed that her scholarship makes, quote, "completely original arguments and represents, quote, a major contribution in the tradition of the post-realist and law and society scholarship tradition that explores how courtroom repeat players exercise power on each other." Another commented that her articles were, quote, "much discussed among criminal law and procedure scholars, and that they locate her at the heart of a new, vibrant criminal justice scholarship." All of this is undeniably true, but I want to add a few more of my own observations. Whether it's in her writings, her classroom instruction, her administrative service, or her fellowship for the rest of us, Margareth is invariably, and I really mean invariably, thoughtful, thought-provoking, careful, balanced, and gracious. I truly love having her as a fellow scholar and teacher, and as an advisor and a friend. Margareth, it is indeed my privilege today to recognize your many accomplishments and confer on you this honor you have most definitely earned. And if you'd stand, I would like to give you this medal marking your investiture as the Carl L. Vacketta Professor of Law.
Thank you. I have to say, I feel like a bit of a rap star. Thank you. Thank you, Dean Amar. Thank you, Provost Congelaris. Honored guests, colleagues, family, and friends. I am deeply honored and humbled by this very generous introduction and this honor that's been bestowed upon me. Provost Congelaris, I know that provosts have to attend such events all the time, but I have seen firsthand the heartfelt and personalized manner in which you approach your role as a leader. I have seen you at memorial services for family of colleagues and at undergraduate dance performances and at high school board meetings, and none of those appear to be merely ministerial performances for you. And I have seen, in this time that I've been here, many visionary and hardworking provosts, but none that are all of those things and still care as much as you do about the people, the faculty, the students, the staff of the institution. So thank you deeply. Before I continue with more remarks and thanks, there's another acknowledgement that I need to make. At the University of Illinois, we begin events big and small with the acknowledgement that the land on which our land-grant university sits is the land of Native nations, and that the best way for our institution to move forward, as it must, is to conduct our work in ways that honor Native peoples and dispossessed individuals everywhere. We do so in part by building a vibrant, engaged community, inclusive of our differences, and advanced by our strengths. Now, our strengths at this institution includes our extraordinary interdisciplinary depth. I've had the opportunity to collaborate with and befriend colleagues from many parts of campus, and I see a number here today, and I'm so grateful for your willingness to take some time and help celebrate this day with me. I know that law school has made concerted efforts to reach across the disciplinary aisles, beyond boundaries, traditional boundaries, and I want to take a moment as well to acknowledge some of the people who I see here today. Dean Investiture Patton, thank you for being here. I see folks from the Provost office, Amy Santos, thank you for being here, as well as many, many colleagues from physics and labor relations and history and English and German. And so I'm very deeply grateful to you all. I'm delighted as well to be joined by close friends and family, many of whom couldn't be here in person. These are strange times with COVID and other things. And I know many of them are watching on the live feed. So I want to thank them for taking a pause from their busy lives, their work, their businesses, their families. And so here with us today, as Dean Amar mentioned, is my sister first, Dr. Anne-Marie Etienne, and my brother, Janad Etienne, who are here with us. We have been the fearless threesome for so long. From the day that our parents left us behind in Haiti to come to the United States to make a way for themselves and for their families, to the day they returned, these two strangers returned years later. In a sense, the three of us have always been together. And in the many hours we spent inventing games in our Brooklyn neighborhood, and much beyond that, you've always been with me, and I appreciate it greatly. I know we all wish that Mom and Dad could be here to celebrate what they would consider to be their greatest accomplishment. Not only the milestones and successes of their children and their grandchildren, but the close family connection that we share. I think they would hold that above all else. Some people collect stamps. Some people collect coins. I collect people. I've been fortunate to have many wonderful mentors and friends who've shaped my experiences, oftentimes by simply modeling excellence, or who have supported me before I gave them any real reason to do so. Some of my closest friends I know are watching, and I do want to take a moment to acknowledge you. David, Katrina, Gail, Nicole, Etienne, and Beth are watching from the various corners of the world as far as Nairobi, Kenya. Two friends and mentors I do want to take a moment to acknowledge who aren't here as well. Natasha Perdue-Silas, the most brilliant litigator that I know, who taught me everything about litigation as a federal public defender, and Richard McAdams, a dear colleague and friend, and often co-author, who has been a real support and mentor to me over the years. Thank you all for sharing this day with me. As you also know, I've juggled administrative responsibilities, overseeing the graduate and international programs at the College of Law most recently. And I manage in some way to juggle that with my teaching and my research. And I've only been able to do that juggling act because of the truly wonderful team that I have the fortune of working with. Christine, Kelly, Athena, Rebecca, Dana, and before that, Matt. Thank you all for doing so much of the heavy lifting and for making my work life a lot more fun than anyone should have a right to expect it to be. But my greatest supporters and those who buoy me day in and day out are my immediate family, my daughters, Madeline and Claire, and their dad, my co-parent and colleague, Patrick Keenan. Parents, we know that we can only thrive in the rest of our lives if our children are supported and safe. And so, Patrick, I continue to be grateful for the love and care you continue to shower on the girls. Madeline and Claire, as I always tell you, you two are my #1 job and my #1 joy. You inspire me, puzzle me, and make me incredibly happy and proud. I love you more than there are stars in the sky, and I'm thrilled to repay you today by providing you a legit excuse to skip some classes. You are welcome. And finally, I want to thank Carl Vacketta for endowing this professorship, for his continued, as Vic mentioned, and unending support of the college. Carl gives back in every way imaginable, whether it's bringing amazing speakers to the College of Law, speaking here himself. I remember many years of seeing him teaching intercession courses. Carl has been a constant presence at the law school for the 20+ years that I have been here. And I'm grateful that with this appointment, I can continue to make his presence felt as I carry his name on the articles I write, the presentations I make, the billions of emails I send on behalf of the college, and to every place around the globe that my work takes me. Thank you, Carl, for supporting the college and for supporting my work. And my work, this is of course the reason why we are here. So it would be fitting for me to spend at least the bulk of my remarks sharing a bit with you about what has occupied my thinking for the last 20+ years and the work that this professorship will help support going forward. So while my scholarship and teaching cover many areas, and Vic mentioned a few, he might have even added a few in there, the center of my focus is sentencing. I've written about policing and the Second Amendment and racial disparities and advocacy and plea bargaining and interrogation and not a lot of other issues in the area of criminal law, but I always return to sentencing. And there are a number of reasons for that. But rather than reciting through with you articles or publications or presentations that I have worked on, I want to take some time instead to share with you why I'm drawn to this area, what the current state of thinking is with regard to sentencing law and policy, and finally, at least one of the ways in which I conceive of some of the most intractable questions we continue to face. So, first, why? I'll start by telling you that there are 3 primary things that have influenced my work and my thinking. We all come to our scholarship with assumptions and with priors, with experiences, and things that influence us greatly. To think otherwise would be like trying to persuade your therapist that your upbringing or family of origin have nothing to do with who you've become, right? So as I share with my students, though, our priors don't mean that as legal scholars we should not rely primarily on evidence, that we should not abide by rigorous analysis, or follow the rules or engage adversaries with civility and open-mindedness. Our priors don't mean that we don't think, rethink, reassess, correct, admit mistakes, and move forward. Our priors don't mean a lack of intellectual humility. But I have come to think that to leave them out of the conversation reveals a different kind of disingenuousness. And so I want to try to avoid a little bit of that today by being as open and forthcoming about that as possible. I would be a different scholar if it weren't for three things. So these are three things that have influenced me significantly. First, my amazing colleagues. I have lived in places ranging from rural Mississippi to the most urban of urban Baltimores, and many places in between. It never occurred to me to live in the Midwest. I came here for one reason. I heard that the University of Illinois knew a little something about criminal law. I have been very fortunate to have terrific criminal law colleagues from whom I have indeed learned a lot. I was drawn here by Wayne LaFave and Andy Leopold, Kit Kinports at the time, and Richard McAdams. Later, adding to this all-star group came Heidi Hurd, Michael Moore, Jackie Ross, Kenworthy Bills, Eric Johnson, and I would add Pat Keenan and Suja Thomas for the overlapping work that they do. They have been wonderful colleagues, consistently generous, thought-provoking, engaging, and remarkably diverse in their interests and their methodologies. My work has been doctrinal, empirical, comparative, theoretical at times because of them. This breadth, I came to this as a practitioner, and so what I learned from them was incredibly impactful. The breadth of approaches is critical, particularly in sentencing law, as I will talk about. It's been a tremendous blessing to me to be part of such an esteemed group, and to them I'm very grateful. The second thing, and I'll say too that I do dabble, but their help, their reading their work has made me more of a dabbler and less of a dilettante, because I have in fact learned so much. But second, I'll say, before moving even to the Midwest, before that influence, I've also been greatly influenced by the 6 years I spent as a public defender, representing individuals who face the powerful and often overreaching arm of government is among the most important, most rewarding, and most noble work a lawyer can do. And so I would agree here with our provost and his uncle Nikolai in thinking about this as a very, very important legal tradition. It's an important American tradition that's lost its luster in recent years, and the tradition of criminal defending does have deep historical roots in the United States, preceding even our constitutional recognition of the right to counsel. Our second president, John Adams, was one of the country's first public defenders. He took a case that no one else would touch, representing the unpopular redcoats that instigated the Boston Massacre. But it was perhaps, the work that I did as a public defender shaped my view of law as a profession, and not only as an academic or as a theoretical pursuit. It elevated my sense of the role of ethics and professionalism in the most adversarial of legal endeavors. A balanced and fair consideration of opposing views derived from a respect for the adversarial system is a leitmotif in my work. It's a theme that I've explored in conferences that I've organized, in work that I've written, and is part of why I think of things as I do. When I wrote defense lawyering was a form of cause lawyering or impact lawyering nearly 15 years ago, I was one of the first to use that phrase, and I believe it today. Third, we all have core beliefs, so let me start by sharing one of mine. If you know me, and you know based on my experience, based on my intrigue with the immigrant story, which to my mind includes the Great Migration, based on my work with international students who seek to write a new chapter, I see many of them here today, based on my time as a high school teacher in segregated rural Mississippi, based on my continued commitment working with K through 12 and working on that in my research as well, Based on that and many other things, you probably wouldn't be surprised to know that I believe in second chances. I believe that one of the most important functions of law is to promote and enable opportunities for self-actualization. The opportunity to write another chapter in which one can realize with one's agency, I think that's important, is something that's very important. With my children in the audience, though, as well as numerous students, I have to be very careful about what I say about second chances. So I'm going to leave it there for now, but I invite you to consider, as I do, what it might mean for criminal law to aspire to something beyond the protection of the most basic human needs of safety from physical harm, protection of property rights. What does it mean for the law to be concerned with the realization of the individual's potential? The pro and anti-death penalty advocates, for example, have it wrong to some degree. Their focus is too narrow. It's not enough for us to be concerned about preserving the opportunity to die at one's natural death or what have you, but also about preserving the opportunity to live. And I think law has a role in that. So, for example, life without parole is hardly life. The law recognizes this with respect to juveniles, but not with respect to adults. So those are some of the kinds of things that I think emanate from that core belief. So I haven't said much about sentencing yet, right? So let me say a few things. I'll start by telling you this. For this conversation, as I mentioned, I do think about lots of other areas of criminal law, but I separate sentencing from other areas of criminal law. I set aside for now the two other large branches of criminal law, the doctrines of substantive crime that occupy the law of convictions for the most part, and the law of criminal procedure, right, that occupies the rules that regulate policing, that regulate prosecutions. The work of sentencing I treat separately. I take that as a focus. It asks the question, once the conviction has occurred, and sadly often once the harm or risk of harm has occurred, after the accused has been arrested and so forth, sentencing asks us principally, what do we do now? And I don't mean to suggest that sentencing is completely separate from substantive law. There are lots of cases and lots of traditions that show us that they are very interrelated. But I do think that thinking about them separately brings particular insights. I'll start by telling you, sentencing scholarship, as I want to argue today, really does need to be treated separately, as less of an afterthought than it is. And sentencing is highly, as a result, because it's often treated in unison or as an afterthought, is highly under-theorized. And that's really part of what my work has sought to do. So let's start, as I do often in class, with a problem. Is it the appropriate sentencing result? Is the appropriate sentencing result one that allows an 18-year-old offender to be in prison for 3 months and perhaps get out, go to college, get a job, live a life, affect others? Or is it one that would allow the 8-year-old victim of that offender to go to college, live a life, be whole, knowing that the perpetrator received a shorter sentence or a longer sentence? Is the appropriate sentence 10 years? Is it 2 years? How do we figure that out? If you watched any of the Supreme Court nomination hearings last week, as I did, glued to the television, this problem should sound familiar to you, right? It's an iteration of a very common sentencing question. If I could give you an answer, though, sort of spoiler alert, I don't have an answer. If I can give you an answer that would satisfy everyone with every different ideology or with their own sets of priors, I would have solved criminal sentencing. But what I can tell you is that I've started to think about this problem, is how I've started to think about this problem. And I want to really devote the remainder of my remarks to a couple of things. One, how we currently think about sentencing choices and justifications. 2, why this is lacking, and 3, a conceptual framework that I've been at least playing around with that may help us in theorizing more about sentencing. So how we currently think about sentencing law. Again, if you were watching any of the Supreme Court nomination hearings of Judge Ketanji Brown Jackson, you probably learned a lot more about sentencing law than you ever want to know, but you probably also learned that it's an intense policy, that there are intense policy and legal debates involved. You would have heard various ideas about how we should be thinking about these questions. But if you don't have the stomach for politics, let me explain a little bit about what was said. So, criminal sentencing scholarship focuses on 5 primary theories of punishment. You may have heard many of these terms before: retribution, rehabilitation, incapacitation, deterrence, and restoration. It's been sort of newly added to the mix. Retribution seeks to deliver to the offender what they morally deserve, a just sentence, a just punishment, no more, no less, based on largely their culpability. Incapacitation, literally and physically often, curtails their liberty and prevents them from committing further harm. Deterrence is preventative, largely, and is aimed at dissuading that offender or other like-minded or potentially like-minded offenders from committing a crime in the first place, or recidivating and committing a crime in the second place. Rehabilitation punishes with the goal to transform the individual from being the kind of person, right, who commits a crime into a law-abiding individual, not merely one who is restrained physically or dissuaded. And restoration seeks to return society as much as possible, and notably here, return the victim as well, to the situation where they would have been in the first place, to the original position, the place equal to where they would have been prior to the commission of the crime. Now, all of these justifications are codified for the most part. They're embodied in law, and that's what we heard about in the hearings last week. All of these justifications appear in U.S., at least on the federal level, in 18 U.S.C. 3553A factors, something I have written considerably about. The statute requires parsimony, stating that a judge shall impose a sentence sufficient, but no greater than necessary, to meet the goals that include deterrence, rehabilitation, incapacitation, and the like that I've just listed. And many states have comparable statutes. Now, for many of us, this raises as many questions as it answers, right? What in the world is sufficient but not greater than necessary? How do we judge? How do we evaluate? How do we measure public safety? How do we get from point A to point B? Even if we did agree on the goals, how do we get from the defendant and the offense to a particular result? None of that is clear with the theories that we currently have. The theories don't really give us a lot more purchase on the how in sentencing. And so the second thing that I want to explain or tell you about is how these theories are how the sentencing law is under-theorized. So many decades ago, Marvin Franklin famously wrote that criminal sentencing was law without order. Much has changed since then. There is law, clear law for the most part, and now with the sentencing guidelines, there is order. There are step-by-step instructions, stage-by-stage determinations for how judges should proceed. So there is law and there is order, but there are very few principles. So the underlying theories of what sentencing should accomplish and how remain lacking. So here's an example. We lack a theory of mitigation. Take intoxication. Is intoxication a mitigating factor or an aggravating factor in sentencing? Is age or youthfulness a mitigator or an aggravator? Let's assume for a moment that crime prevention is your goal. Like we could agree at least on one of the goals of punishment, and that it's going to be to prevent crime or deter crime. Well, there are things we know about how to prevent crime. At least one important one is that criminality correlates significantly with age. offending rates are highest among males aged 16 to 26, and they drop steeply. So what do we do? What do we get for our sentencing resources when we sentence a 50-year-old to 10 years in prison, when it's highly unlikely that at that age there is much criminality left? What do we get? So typically what we get, at least in part, is very high medical costs to be paid by the Department of Corrections. On the other hand, sentencing a 16-year-old to 10 years in prison is a lot more meaningful incapacitation, right? You get a lot more for your sentencing buck in that. But we also know that the law actually moves in the other direction, right? Juveniles, for the most part, are argued, should have lower sentences. And it's not with account to what it is we're actually receiving, because we don't have a clear idea of what role age ought to play. Or we have one that's based on these sort of outmoded, or not outmoded, but fairly capacious theories, right? A lot can be thrown into deterrence or crime prevention. It can mean a lot of things for a lot of different people. And so if we start to think, right, these questions are important, not just for the 16-year-old or the 50-year-old, but for society, because sentencing resources are not free. They're fungible with other government resources that could be spent on education or healthcare or infrastructure or innovation. And so sometimes a lack of mitigation policy leads us to overspend on sentencing in some areas that might actually align with what we think are our priors, but don't work with what we think are what the goals we're trying to achieve. And they lead us to underspend in other areas. When we buy more punishment than we can afford, the consequences are dire for all of us, not just for the defendants and not just for the victims. These questions matter on whatever side of the ideological or political spectrum you fall. So, but we don't yet have a clear way of thinking about them. A principle that takes into account the realities on the ground of how sentencing works and what sentencing means is as important as theories that account for more general philosophical ideas about what sentencing ought to mean. You need something beyond the 5 justifications of punishment. Are there tools? Are there ways that we could think about this that might be helpful? And this is my last point, and I'll share this with you as I provide a kind of one glimpse, anyway, one of several glimpses into the way that I've been thinking about sentencing, and particularly the way sentencing theory should work versus how it does work. Now, like many of you lawyers in the room, I went to law school because I didn't have the stomach for medicine, like my sister. I didn't have the head for mathematics, like my brother. But one of the things I do appreciate about being a law professor and a practitioner is the opportunity to learn about and incorporate theories and methodologies from other fields: psychology, sociology, economics, statistics, humanities. So I invite you to think for a moment. Consider this thought experiment. What if we thought about sentencing as a black box system, right? Even lawyers know enough math, I think, to recall the simple exercise that we all learned in 3rd grade, right? You're given a column of numbers on one side, a column of numbers, outputs on the other side, and then there's a box with a function, and you've got to figure out what it is the box is doing. You can imagine the easiest example, and probably the only one I could solve. Imagine a 2. The number 2 is the input. The number 4 is the output, right? That function could mean a lot of things. It could mean +2. It could mean ×2. It could mean squared. It could mean minus -2. See how I showed off with that? Or something else. Now, obviously, our friends in engineering, computer science, and other systems design fields work with far more complex versions of the black box. But for our purposes, that's all you need to know, so don't be afraid. To continue the analogy, right, in sentencing, we know the input, right? We know the offender. That's typically how we think of it. We know the offender. We know the offense characteristics, right? We know the history, the background other information about the accused. We know a lot of information about the offense, right? How much money was stolen, what types of drugs were involved, whether a firearm was used, was somebody injured. We also know the outputs, right? Whether the former offender is able to be a productive member of society, whether there is recidivism, what the community's crime rates are, whatever it is that matters to you, right? We can think about what those outputs were, what the costs are on society, how efficient is our punishment scheme. We know a lot about the functions in the box. We think we know a lot about the functions in the box. And I think many would look at the sentencing scheme and actually think this is a white box, right? Because we know the law. We know that Section 18 U.S.C. 3553A or the particular sentencing guidelines are the function that go through. And yet, there's something that's lost, right? I would argue that the law, right, as lawyers, is perhaps an input and not a function, and that we still need to look for the function. But thinking about sentencing as a closed system gives us insight into a lot of the major puzzles in sentencing. So disparity, for example. We think a lot about racial, gender, socioeconomic disparity. If the inputs are identical and the functions are identical, but we regularly get outputs that show that, for example, women typically receive lower sentences than men, and that's true except for certain kinds of crime where women do things that are not women-like in some way, killing their children or, killing their spouses or things like that. But typically women do get lower sentences than men. So if we know that the inputs are the same with all factors being equal, and we know the functions are the same, the law is the same, but the result is disparate, then what do we know about whether that law is gender neutral, right? Is the scheme gender neutral if we can see, if even with the same function, the results are different? Lots of debates about evidence-based sentencing and algorithm. How easy is it to reverse engineer the outputs is essentially the question that's asking, right? If we know the output we want, can we create an algorithm that will produce that same output, and what are the dangers of recreating a system that mirrors the existing outputs? Ethics. How important is parity among legal advocates in our adversarial system? Should prosecutors and defense attorneys operate by the same rules? Should they be equally funded? Is the quality and zealous advocacy or effective assistance, are those inputs? Right? Is the quality of the attorney an input? Is it a function? What does that mean about the output that we're likely to get? Because if we spend a lot of time reforming something that really is not critical or in the wrong way, then we are also engaging in a loss of resources. And then I'll add to this the classic philosophical debate of sentencing, right? If you think about this as inputs and outputs in a black box system. Imagine a sci-fi movie where you've got two, and I'm not a big sci-fi person, but you've got two identical defendants with identical characteristics, identical offender characteristics, equally horrendous crimes, identical in every way. So the inputs are the same. Each is magically beamed away to a distinct location upon conviction. They return a year later, and one is a much improved member of society, productive, reintegrated, all of the things that we might seek regardless of what your sentencing goal might be. The second commits another terrible, horrendous, similar crime, re-victimizes somebody else immediately. Do we want to know where they were beamed to? How much do we care about what's in the box? Ask yourselves, right? Do you want to know what happened to each? What if you learned that after committing this terrible crime, the one who came back reformed had gone to a paradise island, right? Where all their greatest dreams and desires were met. The other was beamed to a hellish location where they were tortured and mistreated. Ask yourselves, which black box function would you prefer? Actually ask yourselves this. And whatever your answer is, what if the results were the opposite? What if it took a heinous treatment and torture to reform on the one side, and the person who went to the paradise island came back much worse off than they had left, right? Can you defend the alternative? And if it doesn't matter, if all you care is about the output, then that tells you something about your own priors, right? And this is one of the classic questions, right, in criminal law and sentencing law. And it's in part of the well-rehearsed debate between retributivists and consequentialists. But if you care about the function, right, if you don't only care about the output, then that tells you something else. And so it is a helpful tool, I think, in focusing where our thought should be, where the principles for sentencing ought to be, where the reforms ought to be focused. The black box scenario helps each of us understand what our own underlying prior assumptions are about what the law should do. Based on my own assumptions I've shared with you, you could probably guess, maybe, how much I care about the function and the output. But what matters more to me is that we each as individuals try to think about answers for this question on our own. As you consider and think about the sentencing policy and law as a black box, maybe you can even think about that over the nice lunch that awaits you outside. I hope it helps each of you answer the question for yourselves, right? What should punishment look like? That's the question I've been asking, and that's the question I plan to continue asking in years to come. Thank you.
Thank you for those very thought-provoking observations and explanations of your own journey. I think we all should congratulate Margaret one more time as we wish her the best in the future, to continue the great accomplishments, continue to write great pieces, teach great classes that in classic law professor fashion don't provide answers, but rather tell all of us to find the answers. In this and other of our great rooms in the building, including the Carl Vacketta classroom, as the Carl Vacketta professor. So congratulations yet one more time, Margaret.